Good afternoon. It's the appointed time. We have a quorum. I call to order a meeting of the Bills Committee. We'll invite representatives from the administration to come inside the conference room as well. If you wish to ask questions on policy-related matters of the bill, please press the request to speak button. I will also remind members that you should disclose the nature of any direct or indirect pecuniary interest relating to the item before you speak on the item. I'm sure you are all quite familiar with this by now. We have Mr. Frankie Yik and Mr. Lee Chen Kang having pressed the request to speak button. All right. Welcome, Secretary and the team. Please be seated. First to speak, Mr. Frankie Yik. Thank you, Chair. Now, I have some more industry feedback to convey. For ride-hailing vehicles, I talked about how depending on the age of the vehicles, inspections may have to be done. I want to ask if there are any differences in the standards adopted for ride-hailing vehicles and taxis. I think in general they should be the same, but I shall await confirmation from the administration. Dr. Chen Pan asked earlier that there should be conspicuous markings for ride-hailing vehicles. We had early in Hong Kong some taxis that would provide a discount. So we had some taxi drivers who would hand out their name cards to the customers, and in the end we had derived from that some white cars, and we have those vehicles that have hire car permits that would display their permits in a conspicuous position. We asked the transport department before to provide on their website the registration marks of vehicles that have valid hire car permits, so that one can know the vehicle is providing relevant services legally. And I want to ask in future whether ride-hailing vehicles will have something similar so that one can check online that a particular registration mark is of a vehicle that is providing legal ride-hailing services. Thank you. Secretary, the suggestion of Mr. Frankie Yik is quite valid. We will take note of your suggestion. I will ask the Commissioner to see if she has anything to supplement at the moment. Commissioner, thank you. For inspections, we ask that at some point annual inspections would have to be done to make sure the vehicles are roadworthy, and we do adopt the same standards to a certain extent for taxis and ride-hailing vehicles, but taxis in particular have taxi meters. We need to make sure the taxi meters are working properly, so there will be checks specifically for taxi meters. But in terms of general roadworthiness of the vehicles, we adopt the same standards. As for whether in future we will have some sort of register for ride-hailing vehicles, we will consider this suggestion. We do require in the provisions platforms conduct due diligence checks, so we already have information on, or we have some sort of assurance on whether the vehicles are providing such services legally. Thank you. I do have some concerns. So there may be those who are registered with platforms, and after that they are handing out their name cards or contact information to passengers, and then passengers can book rides without going through the platforms. So how we are going to tackle such irregularities, which I believe will happen at some point, is something we should do. We need to ensure that there are safeguards in place. Switching to another point. We have recently talked about some e-policing measures. We had some concerns about how we may not know who is driving a particular vehicle. So we have some citizens lodging complaints against a certain vehicle, but when the transport department checks the registration mark, they find out about the owner, and the police will send a letter to the vehicle owner asking them on a certain date at a particular time who was driving the vehicle. And right now there's a loophole in a way that the vehicle owner could say they didn't know who was driving the vehicle, and even if they are convicted in the end, they're handed out a really light fine. So one should say if they find out their vehicle is stolen, they should report it stolen. The other scenario is some are hanging false license plates. The third scenario is they have falsely registered a vehicle registration mark with the fraudsters or with the criminals' information, so the actual owner would not know what is happening at all. I think we need to prevent abuse of the system. Earlier, the administration said in their briefing how they are going to tackle such abuse, but I don't think there are anything in the provisions. So I think we need to follow up on this. Well, to facilitate the smooth conducting of the meeting, if there are no objections from Mr. Lee Chen-kung, perhaps we can let Mr. Frankie Yik ask all his questions before we ask Mr. Lee Chen-kung to speak. I have no objections, Chair. Thank you, Secretary. Thank you. What is important in this bill is the introduction of a regulatory framework for ride-hailing vehicles. The vehicles and drivers providing services through the platforms need to be issued with permits. The platforms also have to be licensed. If there are no valid licenses and or permits with the vehicles and drivers, there are penalties imposed on the individuals as well as on the vehicles. We believe with this regulatory framework, we will be able to combat acts of illegal carriage of passengers for hire and reward. And I believe that is a safeguard for passengers. The member also mentioned some unlikely scenarios where criminals using different ways perform acts of illegal carriage of passengers for hire or reward. We have two ways of combating such act. After a driver is convicted, we hand out a penalty for disqualifying the driver from driving for a period of time. In other provisions, it is not necessarily the case that their licenses will be suspended and how long it will be. In our provisions, we have imposed this suspension of not less than 12 months and not more than 3 years. We believe that is an improvement. The member also mentioned how in police enforcement, when acts of illegal carriage of passengers for hire or reward by motor vehicles is detected, the court may detain the relevant vehicles. This is a great deterrent for drivers and, by extension, owners. Of course, the police have their procedure of confirming with the vehicle owner who the driver is, and then they will initiate the relevant legal proceedings. In future, for ride-hailing vehicles, under the regulatory framework, we believe what we have proposed in penalty is already quite deterrent. But if we have some unscrupulous individuals still attempting to perform the act of illegal carriage of passengers for hire or reward by motor vehicles, we are actually planning some legislative amendments to combat this. If the police find evidence of certain vehicles suspected of being involved in illegal carriage of passengers for hire or reward by motor vehicles, if the vehicle owner cannot be identified or the vehicle owner does not say who the driver was, we can still detain the relevant vehicles. These are some enhanced arrangements we have in mind. As for the implementation details, I will ask the Commissioner for Transport to supplement my reply. We do want to listen to the feedback of members and provide updates to members when necessary, when we have the updates. Commissioner. Thank you. Indeed, in police enforcement, we have seen perhaps a vehicle involved in the activity of illegal carriage of passengers for hire or reward, and the police will ask vehicle owners to provide details on the drivers. We will continue to adopt these arrangements for ride-hailing vehicles. If the vehicle owner refuses to provide such details, before we can only detain vehicles after a driver is convicted, but in our provisions, if the vehicle owner does not provide relevant details after the police have performed their procedures, we can still have temporary suspension of the vehicle license and detain the vehicle. We believe it will be a great deterrent for drivers and owners. And for the specific regulations. We will provide for the procedures. We do want to provide such regulations for consideration of members in due course. Thank you. Mr. Frankie.
Well, today, in your electrical brief, you've already set out something, and yet no details have been given. So before the second and third reading, will you be able to come up with the further amendments? Thank you, Mr. Frankie Yik, for bringing this up, because all along we have attached a lot of importance to the law so that it would be able to plug the loophole, so to speak, and also to further strengthen the provisions, and as the Commissioner just set out, because the process and procedures would involve the police as well as the transport department, and there would also need to be an order to impound the vehicle. We have not slowed down at all, and we are actually making every effort to make sure that it's in place before its commencement. So we are actually thinking about this, and then after the meeting we will do our best to come up with the proposed enhanced provisions. We are actually trying our level best so that by tomorrow, that is within this week, we'd be able to pass it on to the Secretariat so that the legal advisor of this council will be able to take a look. We hope to be able to make sure that this Bills Committee will be able to scrutinize it. So the time pressure is tight, and yet we hope that the regulatory framework will become more comprehensive and be able to respond to the community, including the sector's aspirations. Thank you. Mr. Yik, I'd like to ask one more question. First of all, I'd like to thank the Bureau Director for committing the entire Bureau to come up with the further amendments. All right, let's say if we are able to include that in the framework so that by Wednesday we'll be able to incorporate them in the passage of the bill. I suspect that you would wait until the end of next year when the whole bill comes into effect before this will also take effect. But then I think the penalty clauses can also be implemented even before the commencement of the bill. Can that be done? Well, our most pressing task is to translate what we just said into the draft text of the bill, and then we would table it before this council for your scrutiny, and then after you have endorsed it, that will be incorporated into the text so that by the second and third reading, that would become part and parcel of the bill for passage. And as we have always emphasized, the bill is to come up with the regulatory framework. There would also be further subsidiary legislation to be passed in order to implement this framework, and therefore they will have to be dealt with as a package of measures. We hope that as soon as possible, with all the measures in place, we'll be able to come up with the commencement date for the bill. I recall that at the last meeting, when we exchanged views with members, Mr. Lai was one of them, and you did indicate that you would need to have a principal legislation that would determine all the principles, and then we will also need the subsidiary legislation in order to incorporate all the details, and therefore we have decided on this negative vetting approach. But still, we'd like to permit this council to have a chance to scrutinize all the details. That would make the whole process more complete, and therefore we would need to look at the principles, and then we will also have to look at the details before we determine when the bill should come into effect. But then as far as we are concerned, as of this year, from January to August, the police have been stepping up enforcement in order to tackle with the illegal ride-hailing activities. Well, upon the stepped up actions, some 80 vehicles have been involved in illegal hiring service, and they have been taken up by the police, and those cases are being processed. So those efforts will not relent. And then with the stepped-up measures under the comprehensive framework, we will also have to be very careful about the commencement date, and yet the enforcement action will not be relented. So we will continue to step up our efforts to tackle the problem. But then, by the time when this bill comes into effect, we would also have to ensure that, when our citizens use the service, their experience will not be in any way affected. Yes, I understand that you've been beefing up your enforcement efforts, but then you talk about some AT vehicles being impounded. But then, looking at the actual situation where there are over 80,000 vehicles providing such services is peanuts, and therefore I hope that you will continue to step up your efforts. Okay, any further questions from Mr. Yik? If not, then Mr. Lee Chan Kang. Yes, I have several questions to follow up on what Mr. Yik has been saying, and also some members have also asked some questions, and I'd like to follow up on their views as well. Well, just now, Mr. Yik also talked about the online checking system for ride-hailing services by vehicles and so on. But then, I would welcome that. But then for anybody booking the service, do they have to immediately check online whether or not the vehicle that they have booked has got the permit to provide such service? Well, I have the following suggestions. Well, in the ride-hailing platform, you can also include due diligence services. For example, definitely those vehicles will have to have the permit, and they must still be valid, right? And definitely the driver's profile would also be included. For example, have they committed any traffic offense in the past, and have they had scores deducted and so on? Because you've already got the offense points system in place. Okay, if he used to be a taxi driver, but then because he has had his taxi driver offense points deducted to such an extent that he would no longer be able to drive a taxi, and then he switched to become a ride-hailing service driver, then the customer will immediately be able to tell. And also, you have also got this point system in place. How are you able to ensure that for those who have been punished before, they would not be hired to provide the service? And also, Mr. Yik also talked about scapegoats. So if you have no idea as to who is behind the wheel, then we would welcome the proposal that the vehicle be immediately impounded. And if that is the case, then of course owners will not dare to do it, because they might have thought that allowing their friends to just drive it once in a while, then that should be okay. Maybe it's just one of the family members doing that, then they would also have to give it second thoughts. And also in the windscreen, you would also have to display certain identification marks like a vehicle permit and so on. But then in order to enable anybody to tell whether or not it's a ride-hailing car, then what about having such identification marks posted on the back screen? It's also on the back window, so that people will be able to tell what is happening. I think that would also enhance the deterrent effect and also the enforcement effect. And next, turning to tax, because we have a very serious deficit problem here in Hong Kong, and people ask about business registration. You said that they would not be required to do this business registration. What about personal tax? Do they have to report it as taxable income? And does the IRD know about it if they try to evade tax? Or else people will just take up such jobs in order to evade their tax. Yes, you were here this morning, right? And therefore some of the issues have been touched on this morning, but then it's okay for me to repeat that here if you want. All right. The first question that you raised, in fact, when I responded to an earlier question by Mr. Yik, I think is a very good point that you made. And this also gives me another opportunity to respond to that. On the website, we do provide such lawful ride-hailing service platforms, and also the driver's profile would also be included. I think that would enhance the transparency so that people can check for themselves whether or not the drivers have the permits to drive. But then not many people would be bothered about this. Well, they might not be bothered to check the numbers, but then for ride-hailing services, precisely, they are using the platform to connect with the customers, and that's a very good communication channel. This is a technology channel made available for customers so that we can make use of that channel to ensure that the users would be able to tell whether or not the service providers are permitted to provide the service, and if they are not in compliance with the law, and if they are not supposed to provide a service, then they have not met the due diligence requirements, and that would attract penalties. And also to make sure that to them, if they have to go on the web to check whether or not the vehicle is driven by someone who is permitted to drive. Well, according to our experience, before the passenger boards the car, they would check on their mobile phones to verify whether or not it's the driver that they have been told, and also whether or not the car number or the car plate number and also the serial number is the same as what they have been told, so that they'd be able to tell whether or not the driver and the car are exactly what they have been informed of while booking the service. And that would ensure a seamless provision of service. And there is no need for them to actually check with the driver himself. And what is related here is the fourth question that you asked. That is about the identification mark. Well, in the bill, you have brought up some detailed issues, and those can be sorted out later. Well, today, what is most important for this Bills Committee is to go back to the principal legislation. That is, it provides that the Commissioner will have the power to determine that such vehicles will have to display conspicuously the proof that the vehicle and the driver are eligible to provide the service. That would already give us sufficient power to come up with the details, for example, as to where the identification mark should be placed, whether or not it should be on the front windscreen or at the back. Well, I think there is a lot of room for discussion. But rest assured, we all agree that proper identification is very important, and it should be easy for the eyes. And other than identifying that the car itself is eligible for providing the service, and whether or not other details should also be displayed is something that we can discuss. Another question is about the point score system, or the taxi driver offense point system. Is there anything that we can borrow from that for ride-hailing services? We're talking about more serious offenses. For example, if the number of complaints has been on the high side, including overcharging, making detours, and also refusing ride and so on. And through the ride-hailing services, if they are to provide the service, then after you have agreed on the fee, and if the customer agrees to the fee, and there is a contractual arrangement, and therefore there is no need for them to pay on board of the car, because through the platform they would already have made a payment, and there is no need for them to pay again on board of the car. There is no e-payment whatsoever, and therefore on overcharging and on making detours, in fact that would have to do with the contractual arrangement, the agreed journey. So that has been agreed upon beforehand, and therefore when compared to taxi rides, I think such situation would be less frequent or rare. So we would be making use of the ride-hailing service platform to regulate their service. Last but not least, you also talk about the point made by Mr. Frankie Yik, that is the stepped up enforcement on vehicles providing the service. He was advocating that we should move amendments in order to fine-tune that. All right, if some cars are used for ride-hailing services, and if you have no idea as to who is behind the wheel, then the cars should immediately be impounded. Well, at every step of that, we will have to ensure that the police, the transport department, and if we were to apply to the court for issuing certain impounding orders, then there needs to be a reasonable time frame for those involved to make representations or provide details before action is taken to impound the car. So we have to be sure that it's efficient on the one hand, and yet at every step of the way is reasonable. So that has to do with the court and also the police. It will take some time for us to work out the details with the judiciary and the police, and therefore we have yet to come up with a CSA, but then we will try as far as possible to do it, because as you can see, it involves certain procedures. We have to make sure that they are reasonable. We have to make sure that it's fair and reasonable to ensure that it's convincing.
As for what the member said about taxes, and we had the permanent secretary answer a similar question raised by members, Mr. Lai Tongquo and Ms. Doreen Kong. We were asked to review the relevant provisions. We were also asked to review the Inland Revenue Ordinance. We will try to incorporate business registration and taxation principles in our provisions so as to ensure drivers and platforms pay taxes as responsible entities, whether they are paying such taxes as individuals or as companies. We just want to make sure there is proper tax assessment. We may not need to spell out everything in our provisions, we believe. In future, we can just have the drivers and platforms fill in information, and they can opt for some options for specifically these scenarios. Thank you. Mr. Lee Chen Kung, I have some follow-up questions. Well, but you've gone beyond 10 minutes. Mr. Frankie Yik has spoken for long, but that's Mr. Frankie Yik. You can speak though. I guess I'll speak for another round then. Thank you. Mr. Sunny Chen. We do want to make good use of innovative technology in transport under the regulatory framework for ride-hailing vehicles to make it simple for everyone, passengers, regulators, platforms. But if there is over-regulation, there will be social costs, unnecessary social costs. I believe we should strike a balance. Different members have expressed different concerns. I want to hear more from the administration on efficiency and actual implementation of the bill, the operability of the bill. I believe that is an important factor for consideration. Can the administration elaborate on their perspective? Thank you. Secretary. We thank the member for providing an opportunity for us to talk about things from a macro perspective. We have seen the first ride-hailing platform in Hong Kong since many years ago, and we only have the new technologies that are constantly evolving, and it is only now that we have seen proper regulation in different jurisdictions. We believe it is right timing for us to do this. We may be playing catch up, but we can refer to the experiences of other jurisdictions as their operations are quite mature now. We can see what we can adopt, what we should give up on. We have 90% of the citizens making use of public transport services. Point-to-point services account for 6% of the transport services provided. We believe with the regulation of ride-hailing vehicles, we should consider how we should have platforms that have great potential from different parts of the world to set up operations in Hong Kong. The percentage of such service provision may not be high at the moment, but we want to create a facilitating environment. We want to regulate such services. We want to make sure such services are provided efficiently. We also want to reassure citizens on the provision of such services. Some citizens express interest in making use of services, but they know the service is illegal. So they want some reassurance when making use of such services. For drivers, they are also essentially exploiting the loophole right now. We also want to reassure, therefore, drivers that it is alright to provide such services, which is why we promulgated this regulatory framework for ride-hailing vehicles. In the design of the bill, we are trying to only provide for necessary controls, and we will hold mostly platforms to be accountable. We can control the operations better with licensing conditions of platforms. We do expect there to be different scenarios, so we want to maintain some sort of flexibility. We don't want overregulation either, because when something that is outside the scenarios that we anticipated, when something like that happens, there may be unnecessary disturbance. We do want the regulatory framework to not only benefit ride-hailing service operators, but also taxi trade practitioners, drivers, so that they can upgrade and transform with such new technologies. Thank you. Mr. Lai Tong Kwok. Ride-hailing vehicle drivers, they need to be issued with permits. Taxi drivers do not need to apply separately after passing the relevant tests. So if a driver breaches the road traffic ordinance and they have been disqualified from driving, how can you have the court disqualify their ride-hailing vehicle driving permit as well? I think right now you do have some relevant provisions, but it would take some time for the penalty to be handed out. So should we have the permit be automatically suspended when one is disqualified from driving? Do you have something like this in mind? If not, will you include this in the committee stage amendments? Thank you. Secretary, thank you, Mr. Lai, for your suggestion. Your suggestion is very much valid. We will review existing legislation and the bill's provisions to see how we can effectively implement the relevant arrangements. Thank you. Mr. Frankie Yik. Thank you, Chair. Taxis have to undergo half-yearly inspections, well, commercial vehicles in general, and they cannot go to any garages for inspection. They need to have their vehicles sent to the Vehicle Examination Center in Qingyi. Is it the same for ride-hailing vehicles, or can they just go to any garages for inspections? Thank you. I believe this is a question on the implementation details. We do not have a specific answer at the moment. We will explore the different options in due course. On inspections for taxis, I think the same principles would apply to ride-hailing vehicles. We want to make sure the requirements are standardized and that the vehicles are safe. It does not have specific relevance to the regulatory framework. We can talk about this when we get to the implementation details. However, we welcome any suggestions from Mr. Frankie Yik. Chair, why I'm saying this is because we discussed this morning. Many drive such vehicles on a part-time basis before, but now people drive ride-hailing vehicles full-time. I believe the mileage will be similar to taxis, so we should implement the same standards for taxis on ride-hailing vehicles. The Secretary also mentioned some due diligence checks to be implemented, to be conducted. But say if a passenger calls a vehicle, how can one make sure the vehicle owner has a valid permit? We have something similar in the mainland. Why I'm asking this is because we have already people driving white license cars, and the passengers had reservations because the drivers didn't know the routes, didn't even know the locations, and it was found in the end that there is a fleet of illegal drivers. So how can we reassure passengers by having them be able to check whether the vehicle is a vehicle with a proper permit and whether the driver has a valid permit? Secretary, I would say this: we would hold platforms accountable. If a driver does not have the valid permit but is allowed to take orders from the platform, that we will penalize the platform. As for when there is a fleet, then that would be a different story. If the platform has not conducted due diligence checks, like I said, we will hold the platform accountable. But if we see a fleet of drivers driving without permits, then the platform may have some malicious intent, or they do not have a valid license altogether. The relevant provisions are considered breach. We have penalties for such breaches. The harshest penalty is on top of a financial penalty. We will, if they are licensed, suspend their license or even cancel their license. There will be follow-up actions. I believe that will be deterrent.
And if that should happen, in fact, at the end of the day, the member of the community, if he's not sure about it, they can always go to the transport department to find out whether or not this vehicle has the necessary permits and so on. And therefore, as I said, the online checking system would also be useful, and therefore we will have to adopt this tripartite approach. That is, both the platform, the service providers, and also the member of the public using the service will work together. And then whoever violates the law, if he finds that he'll get into trouble, then he'll be deterred. And therefore, if there are different ways to expose this, then I'm sure there would be very little incentive for him to do it. Yes, I've heard what the Bureau Director suggested, but then I'd like to suggest this. That is, the taxi driver will have to make sure that his driver's permit will be displayed at the front of the car. So will the future ride-hailing service drivers be required to do the same, so that I know whether or not the vehicle is lawful, and also I can also verify the identity of the driver, whether or not he looks exactly the same as the picture shown on the card. Will that be done? Yes, we will look into that. And also for the driver's permit, should that be in a paper form, or should it be in a card form? Well, that's something that we need to look into too. Well, you talk about the driver's permit. Well, if somebody intends to do something, then of course he can always get away with it. For example, I can have 4 different friends from different places, and then they can use my phone, and then they can take orders, and then they will be able to provide a service. So long as every order that is placed on the platform will be verified, whether or not by way of face recognition and so on. You would also have to use your fingerprint or whatever. Then that would help deter somebody who intends to commit the offense, because there is no way that you can falsify the face recognition details or the bio data. And also, I am not suggesting that the identification mark should be displayed all over the place. It should just be displayed at the front and the back of the car. And also, when you go overseas, for some lawful ride-hailing service platforms, after you have booked a car, then immediately they would show the car plate number, and also the model, and also the surname of the name of the driver, and whether or not the driver has had points deducted from his profile and so on, whether or not he has committed any prior offenses and so on. And also, the customer can also share the journey experience with his friends and relatives. For example, you might be calling the service on behalf of your family member and so on, and in case of emergency, they can also call a number for help. So I hope that you can also look into those. If we are able to make sure that, well, for those who intend to provide illegal service, then they have to be caught, and then that will be all right. Okay, thank you, Mr. Lee. You have already gone one step further to think for us. I fully share your sentiments, and whatever can be done will be done. Rest assured about this. And also through the regulatory details and also the permit conditions, we will make sure that we will move with time, and then we will look at the needs of the community and members of the public. And then as we go by, we will try to see what is needed, and additional provisions can also be included as needed. But then we have already provided a very clear legal basis so that we will be able to beef it up in the future. But then I'm grateful to Mr. Lee for your comments. We will have to work harder in the future. Any further policy issues to be raised? If none, then can I invite members to start with the clause-by-clause examination? Can I refer you to the marked-up copy as well as the blue bill? And then I'll invite the administration to walk us through that. Well, here I'd also like to say that we will be looking at the Chinese version, but then legal advisor will be looking at the English version. And then when necessary, the legal advisor will also remind us of the details that we need to look at. Over to you. Yes, with regard to this bill, well, let's look at the long title. The purpose of the bill is to amend Cap 374 to regulate ride-hailing services and also to ensure that there would be a regulatory system or licensing system for the platforms, the drivers, and the service providers. If certain services booked through licensed ride-hailing platforms, we would also be able to make sure that it's done properly. And we would also be targeting illegal carriage of passengers for hire or reward. And altogether, there are 3 parts, 17 divisions. First is preliminary, the short title and commencement. Well, in the blue bill, that is on C3885. That's the short title and commencement. As we said earlier, the overall legislative timetable is as follows. That is, in the first half of next year, we'll be submitting the subsidiary legislations to this council and also the technical details. And then in the second half of next year, we'll be inviting applications depending on the progress of the preparatory work. The Secretary for Transport and Logistics will be able to publish the commencement date in the Gazette as to the provisions. The second part is the enactments amended, and we have set out that well, parts 2 and 3 will be amended as set out in these 2 parts. Next, part 2, amendments to Road Traffic Ordinance, Cap 374. We are aware that the legal advisor has also looked at this part, and he has also written to the administration on Tuesday. So when I move on to that part, I'll be making our response, and the written response will also be forwarded later. Now, on clause 3, just a moment. I can let me remind members. You can always ask questions as we go by, and then all you need to do is to press a button. Okay. On C3889 of the English version, well, it's clause 3, is to amend the interpretation clause, and it's a drafting change. That is, we'll be repealing section 2, and that will be moved to another part. And also, we have also got a new definition of public service vehicle, and that would also point to 55A, and then we will discuss further about that when we are on 55A. And then clause 4, that's on the second page of the marked up copy. So that would be in Cap 374. We will have an additional section 2C on the definitions, and also it's about public transport service vehicles, and then we will have a new section 2C. So ride-hailing passenger transport service will be treated as public transport service vehicle, and then 2C will further explain as to the provision of our public service vehicles. So it's a motor vehicle, well, from the time that it has taken on an order to the time when the service is completed. During that period of time, we would treat that motor vehicle as a public service vehicle. Ms. Doreen Kong. Thank you, Chairman. I'd like to ask the administration this. Well, what is meant by a motor vehicle providing ride-hailing service? We have the start time and also the completion time. So why is it defined that way? The reason why I'm asking, that is, let's say if the car is moving around in the street, but then is connected online, and yet it has not taken that order. So it will not be treated as having, or it will not be treated as providing a public transport service. So would there be some problems with that? Yes, you have highlighted the point that according to our understanding, that is the modus operandi of such service. Well, the vehicle is already online, but then the driver has not taken that job order yet. So even though he has been online, it doesn't mean that he's already running the service or he has carried a passenger on board. And therefore, in the spill, in the latter part, we will see the relevant provisions, and then we will have a very clear definition as to when it will be treated as a it will be treated as a public transport or public service vehicle. So that would be at the start of the journey, and then upon the completion of that journey, that would be the time when he has already completed that order. And during that time, he is providing a public transport service, and after completing that service, he will no longer be treated as a public service vehicle, and he will then become a private car again. And therefore, we need to have a very clear definition so that when they are providing the service, where there is an accident, then we will know whether or not this private car is used for a higher service, and whether or not he would be held liable for certain offenses and so on. Yes, can I comment on that, Chairman? Yes, please. Okay, there might be a scenario if he is a ride-hailing service vehicle. Well, he has not taken on board the passenger, and yet he is online. But then, in the course of going to pick up the passenger, he might have knocked down a passenger or knocked down somebody. Then he would not be covered by the ride-hailing service insurance policy. Is that the case? Because in the US, let me give you an example. There will be 3 stages of calculating the insurance premium. That is, as soon as he is online, then the damages paid would be less. And then after he has taken the job order, he's on the way to pick up the passenger. And third is when the passenger is on board the vehicle. Then in calculating the compensation to be paid out, there would be different calculations. So I'd like to point that out so that I understand how you're going to do the calculation. Yes, let me supplement. I think Ms. Kong is has raised a very reasonable question. That is, in considering the drafting of the bill, we have also considered different details because, well, the car will be converting from a private car to a car providing ride-hailing service. And therefore, legally speaking, we believe that the clearest definition and most easy to understand way of defining it is when the passenger is on board of the vehicle, and therefore that would be the final part of it. But then that's just how the law works. But then for insurance products, we will have to take it up with the insurance sector. Is there a need for them to do anything further? Because in Hong Kong's context, indeed, we have taken reference from overseas experience, because as soon as they are online, we expect that in Hong Kong's context, they would actually have stopped in a particular location, and of course it would take some time in between the time when they take the orders to the time when they pick up the passengers. They would not be moving around in the streets looking for passengers, and therefore they would not just be wandering in the streets for passengers. But then from the insurance perspective, they would prefer to adopt a more simple approach, because when they are treated as private cars, they would already have third-party liability insurance, and then when they pick up passengers, then they would have to pay for an add-on, so to speak, as Ms. Kong just suggested. But then legally speaking, obviously, we believe that this definition would be clearer and also more preferred.
Mr. Lai Tong Kwok, I have similar questions. For 2A, it says the beginning when a booking of the service is accepted by the driver of the vehicle through a licensed platform. This timing is very clear. But for B, when you say the service is completed, when would it be? Is it that one has already paid but has yet to leave the vehicle, or is the passenger out of vehicle, that is when it would be regarded as the service is completed. As said earlier, this may affect insurance. I think we need a clear definition for this. This is my comment. I have another question for the administration. You said here specifically the service has to be made through a licensed platform for the vehicle to be seen as a public service vehicle. What Mr. Frankie Yik said, we have those doing business outside of the platforms, not going through the platforms. They are seen as white licensed cars, correct? Secretary. With the bill and this meaning specifically, if we have a driver that is an owner of a ride-hailing vehicle, they are registered with a licensed platform, but they maintain communication with some passengers. They may have a valid permit if they do not receive bookings through licensed platforms. They are conducting white licensed car business. As for what Mr. Lai said about the service being completed, I guess we can all agree that there should be a clear distinction, but the interpretation, I believe, can wait until we publish administrative guidelines and we can provide the details therein. Thank you. Mr. Chen Puleng, I think what Ms. Doreen Kong asked were quite valid and they're quite pragmatic. So if a vehicle is used for two purposes, they would probably need to have two insurance companies providing two different policies, but that would mean for uncertainty. So the insurance sector has already explored different options. If we have private cars, they already have policies, right? We can just do an add-on for ride-hailing vehicles. Then that would eliminate the uncertainty, because that would mean the liability is only with a single insurance company. There will not be potential shirking of responsibilities. I believe this approach is ideal because it should minimize confusion and disputes. With the beginning and the end for ride-hailing vehicle providing ride-hailing passenger transport service defined, I believe it would make clearer delineation of responsibilities. That's just my comment. Thank you. Mr. Kevin Choi. In terms of the drafting of provisions, we believe there's no need for further amendment. We will discuss with the insurance sector in detail the specific implementation. Thank you. Mr. Frankie Yik. We had some platforms that said they had comprehensive insurance. Of course, I had reservations, but that's not exactly the point. I want to ask, when you're talking about insurance, you expect the drivers to purchase their own insurance, or would you have the platforms purchase insurance on the driver's behalf? Mr. Kevin Choi, for this bill right now, the responsibility lies with the vehicle owners, but of course some platform may want to provide their own insurance to drivers. Ms. Joyce Cook, please proceed. Thank you. We now have Clause 5, amending Section 13 so as to add a reference to 55 set C, so as to provide for the Commissioner and others to act in charge fees. Clause 6, it amends Section 15 of Chapter 374, again adding a reference to 55 set C, so that contraventions are seen as offenses and there will be penalties. Clause 7, it amends Section 52 C3893 in the Blue Bill. We have added a subsection 3A to say subsection 3 is subject to Section 55C. We also say after Section 52.5, subsection 5A, so that when it is subject to Section 55C, subsection 5A does not apply to a ride-hailing service licensee when a booking is made through the licensee's license platform. Thank you. I have a question for 6A. Can you say specifically it has to be a valid certificate? Because a certificate can be invalid, right? I think it is very important because you are providing A or B here. Thank you. Mr. Kirk, I believe with these provisions, it does not mean when one has displayed a certificate that would automatically mean one does not contravene subsection 6. I guess we can provide for when one is displaying or producing an invalid certificate, we can have specific penalties. That is what we can add. Sure, that sounds right. Thank you. Ms. Joyce Cobb, please proceed. We need to have for subsection 5A, because some license platforms may have ads to recruit passengers, so we say specifically that subsection brackets 5 brackets A does not apply to a ride-hailing service licensee. As for subclause 3, after section 52.6, we are going to add a subsection 6A. As said earlier, ride-hailing vehicles would in general be parked. They would not be going around soliciting passengers. For ride-hailing vehicles, when they provide passenger transport service, they will display a certificate. So under 6A, with the displaying of such certificate, they will not be seen as having contravened subsection 6. Or if they have indicated on the license platform the vehicle is available for providing ride-hailing passenger transport service, if they are traveling on the roads, they will not be seen as having contravened the relevant section for soliciting passengers. The legal advisor asked about this clause in particular. For the certificate issued under the ride-hailing regulation, we believe this drafting is already quite clear, and it only appears in Chapter 374. There is no need to, as suggested by the assistant legal advisor, that we need to add a definition for ride-hailing vehicle certificate, we have provided a tag definition here to make things clearer, easier to read. Please proceed. Clause 8, Chinese motto copy, page 10, C3893. Still, we are adding part 6A after part 6. There are six divisions. Let me first talk about division 1, interpretation. We have a new section 55A, capital A. So we have for license platform, the passenger transport service, we have definitions. For platform, ride-hailing platform is defined as an electronic or telecommunications platform through which ride-hailing platform service is provided. Basically, it connects drivers and passengers. They make use of third-party drivers to provide services, and we have more details in ride-hailing platform service to distinguish between the different types of services that may be provided. We now also want to talk about a definition for ride-hailing passenger transport service, a service for the carriage of any passenger for hire or reward that is booked, and the location for picking up the passenger is determined at the time of booking of the service. We have a definition here specifically to say the service is provided by using a private car in respect of which no hire car permit is in force. Mr. Gary Zhang, I want to ask, what is the difference between an electronic platform and a telecommunications platform? I don't know what exactly the difference is. As for ride-hailing passenger transport service, in its definition, point B, it says the location for picking up the passenger is determined or substantially determined at the time of booking of the service. Why do you need to include this part in definition? Deputy Secretary. Mr. Kirk Yip, thank you. For portals of platforms, they will be regarded as an electronic platform or just electronic or telecommunications platform in general. Even if one makes a booking by phone, that would also be counted. What was the next question again? I asked why there has to be a part B in the definition of ride-hailing passenger transport service. We understand that in general, when bookings for ride-hailing vehicles are made, the location for picking up the passenger is substantially determined. So basically, when the order is initiated, one has to say where they are to be picked up. So we included this part to say this is part of the service. But this is just your general observation of ride-hailing passenger transport services right now. Why do you need to spell that out in the definition? I don't quite understand this. Why does this make for a ride-hailing passenger transport service? Because we want to incorporate the element of bookings. And as you said, we have observed this is how ride-hailing passenger transport service works at the moment.
All right, Mr. Chen Cho-hung. Thank you. Okay, will there be confusion? between booking a taxi and booking a ride here. Thank you, Mr. Ten. Policy-wise, if it's a ride-hailing service platform and if it's providing pure taxi service, then that would not be subject to the regulation here. Okay. Please move on. Next is about 6A. It's about the basic requirement in providing the service. That's C3899. Anybody providing or running the platform, and when a ride is booked through such platform, and if it's the whole or part of it is within Hong Kong, then whether or not the person is in Hong Kong, he will have to get the ride-hailing vehicle permit, and if he runs the service illegally, then that would attract a penalty, and as it would take time to conduct the investigation, and therefore we have decided that the investigation period or the prosecution period would be 3 years, much longer than the normal period. And some have asked whether or not this is a strict liability offense. Well, the original intention is indeed that this is a strict liability offense, and therefore under the common law, honest and reasonable belief would also be a defense, and that would apply to the defendant. That is, so long as he can prove that he has this belief, then he would also have to take up the evidential burden. Sorry, Ms. Kong. Chairman, I'd like to ask 55B1. Under 55B1, just now the colleague has made it very clear that is a person, if he runs a ride-hailing platform, then he must make sure that the ride-hailing service license is enforced in respect of the platform. And then for the ride-hailing service platform, in the earlier page, we have already defined that is under A and B. In other words, he will have to take the order, and he has to be connected with the customer or passenger. If he is doing so illegally, then he will have to fulfill both A and B. That is, if he has just taken bookings, then the platform will not be committing an offense under 55B1. So can you clarify that? Yes, our understanding is that basically when the platform is running a service, then it will have to take the bookings, and then arrangements will have to be made between the driver and the customer before the platform can provide a comprehensive service. And if it has just taken bookings, it's not a completion of the service, and therefore the passenger will not be able to get the service through making the bookings. And therefore the whole process is that it has taken the booking, and then arrangement is made for the driver to pick up the passenger, and then the journey is completed, then is the completion of the service. So long as you have not omitted anything, that would be okay, because I suspect that people might just be doing one thing without doing the others, and then they would not be committing an offense under these rules. Well, under 55B2, you talk about the whole or part of the process that has to take place in Hong Kong. Okay, the platform would only allow the service to be provided in Hong Kong. So how come you have this notion that part of it that is performed wholly or partly within Hong Kong? Well, under the regulatory framework as we propose, that is, after the permit has been issued, then these vehicles will have to operate within Hong Kong. But then at the same time, we are aware of the fact that we have also introduced that we have this higher permits that would be issued, and under this network, you can also have this cross-boundary hire service for rewards. So that would also be permitted. And if the passenger can call a ride-hailing service online, and at the same time, such hire cars can also have that displayed on the car, and therefore when you book a ride, and if you need cross-boundary service, then through the platform you can also call such service, and then such cars will then be able to provide a service, and part of the journey will take place within Hong Kong and part of it will be outside Hong Kong, but then that would only be confined to vehicles with proper license. That is, they are permitted to provide cross-boundary services for hire and reward. Can I supplement? Because right now, under 55B, is there to regulate a service that has to be licensed, and therefore the framework will have to be broader. Or else, it would be like, some cars would be providing service within Hong Kong partially, and then they would not be regulated. If we do not spell out that the service has to be provided wholly or partly within Hong Kong, because it's a service that has to be licensed, and therefore the scope would have to be broader to make sure that whether or not they are running the service wholly in Hong Kong or partly in Hong Kong, they will still be required to get a license. So that's the legal framework and also the reason why the provision is drafted that way. Next, Mr. Gary Zhang. Yes, two questions. 55B subclause 4. The prosecution for an offense may only be started before the end of 3 years, beginning on the date on which the offense is committed. The reason of extending this to 3 years. So is there a necessity for it to be extended to 3 years? And also 55B in Chinese. They say that for any ride-hailing platform, for providing ride-hailing platform service. So for ride-hailing platform, should the English be passenger service or ride-hailing platform passenger service? Let me answer your question. On the 3-year prosecution period, why 3 years? Because bearing in mind the fact that the platform is running a service, whether or not it's illegal service, so in terms of collection of evidence and so on, it might take longer, and therefore 6 months might not be adequate in terms of collection of evidence, and therefore we have extended it to 3 years to ensure that our law enforcement agencies will have sufficient time to collect the evidence and take out prosecution. And then for ride-hailing, the English term should be ride-hailing passenger service. And then 55C. That's on C3901, and that's on page 13 of the marked up version. So first, the private car is a private car with ride-hailing permits, and the person is a ride-hailing vehicle driving permit holder. The service is booked through a licensed platform, and if somebody allows somebody to drive a private car, for this, it would not be treated as illegal. And then 55D, that's on C3903 in the English version. Ride-hailing service licensees must ensure vehicles and drivers have valid permits. And if they violate that, that would be an offense. And for the first commission of offense, a fine at level 3, imprisonment for 6 months, and then on each subsequent conviction, imprisonment for 12 months, and then a fine at level 4 in respect of each non-compliant participant, that is $25,000, and a defense for ride-hailing service licensee charge can also, if he has already taken all reasonable precautions and exercised all due diligence, would also be taken as a defense. And then a question has been asked as to whether or not sufficient evidence to raise an issue would be a sufficient defense. The common law defense of reasonable doubt would not apply here. And also on the penalties. Under Cap 374D, 12T, for a licensee of this, if he's running a taxi service, and if the taxi fleet is not used for providing ride-hailing service, then they could also be fined $5,000 and an imprisonment for 6 months. Comparatively speaking, ride-hailing service licensee would be facing heftier penalties. In fact, I'd like to point out that these situations are very different because for the taxi fleet operators, basically we are looking at the permit holder. So we are, you're talking about the taxi, not the fleet itself. In fact, if a person is using a private car to pretend that it's a taxi, and if he's providing the service, then he has already committed an offense under that, and he's using the private car for reward and hire. And then if it's a first offense, he'll be fined at level 3, and then he will be in prison for 6 months for the first time, and on subsequent convictions, he will also be fined at level 4 and in prison for 12 months. And if he tried to paint it in such a way that it pretends to be a taxi, then he would also be committing an offense under Cap 374A, and he would also be fined at level 3 and imprisoned for 6 months. Ms. Kong? So it's about 55 D3. So it's about the ride-hailing service licensee. He will have to ensure that there will be no drivers or vehicles that would participate unlawfully. So he will have to take all reasonable precautions and exercise all due diligence to avoid the commission of an offense. So if the permit is A, and then the driver, on the day of the journey, someone else drives the car instead. So can he invoke the defense under subclause 3? That is the ride-hailing service licensee. How can he be treated as having taken all due diligence? For example, you said that you have to use AI, and you also talk about the in-car cameras, so that when the person starts the service, then he will have to turn on the camera before he can prove that he has already exercised all due diligence. Well, it would be up to the court to determine whether or not the evidence is sufficient to prove that he has already taken all reasonable steps to prevent that from happening. But then what you said was reasonable, because for different platforms, they are using different technologies to make sure that eligible drivers and also a vehicle that is eligible in providing the service will be used. That is, before he starts work every day, then he will have to turn on the camera, so that through face recognition and even voice recognition will be able to verify the identity of the person. And also at different times, they will also be conducting spot checks to make sure that in between taking different orders, it would be the same person, same driver providing the service. So that would be in accordance with the registered details when it comes to the provision of service. So it's not too difficult to ensure that those steps are taken. So they can use these as evidence that they have taken or they have exercised due diligence. Okay, next is about 55E. So that's on page 15 of the marked up copy, and it's on page 3905 of the marked up of the blue bill. So that's about a ride-hailing vehicle must be driven or used by its owner for providing ride-hailing passenger transport service. So it's about linking the two. So for any offense, they would be committing an offense and is liable on conviction to a fine at level 3. And some have asked about the nature of this offense. Well, it's the same as 55B. It's a strict liability offense, and therefore under law, honest and reasonable belief would only apply to the defendant. That is, the person will have to take up the evidential burden in proving that he has already discharged that duty.
Next, 55F. Ride-hailing service licensees must ensure drivers are owners of vehicles. If they do not do so, they will be liable on conviction to a fine at level 3. If the licensee has taken all reasonable precautions and exercised all due diligence, they can raise a defense. We have also said we would also like to address the point made by legal advisor. Again, we would say the common law defense is not applicable. Mr. Ring Kong, you did say 55D and 55, or actually 55D and 55F are very similar, but then 55F has much larger penalties. When you say the offenses for 55D and 55F are similar, but they have drastically different penalties, what are your justifications? Often when one breaches Section 55D, it would mean that one would have also breached Section 55F. Why do you have different penalties? Mr. Kirk Yip, thank you, Mr. Kong, for your questions. There are differences in where the responsibilities are. One is on when a platform provides drivers or vehicles that do not have valid permits to provide services. There will be certain penalties as set out in Section 55D. But for Section 55F, it is about how drivers and vehicles have valid permits. But there is a disconnection between the drivers and vehicles. The platforms have to make sure drivers are owners of vehicles. So we anticipate there may be a case that a driver may have a valid ride-hailing vehicle driving permit, but they are not driving their own vehicle. So there will be penalties. We do see this as being less serious, which is why we have lighter penalties than those in Section 55D. The provisions are similar, but we think the nature is quite different. So we have different penalties. Thank you. Mr. Martin Liao. I want to ask about subsection 3. So it says here, it is a defense for a ride-hailing service licensee to establish that the licensee took all reasonable precautions and exercised all due diligence to avoid the commission of the offense by the licensee. So with the English version in particular, it said took all reasonable precautions and exercised all due diligence. In common law, we often say exercise reasonable care and taken all precautionary measures. It seems that we are using quite different wording here. Are you trying to say the same thing here as what is generally in common law? Who is going to answer this question, DOJ or someone from the Bureau? Thank you. For took all reasonable precautions and exercise all due diligence. We have quite a number of defense provisions in Hong Kong laws that make use of this expression. We have referred to similar defense provisions when we use this expression. Basically, are you referring to case law to excuse your use or your non-use of a common law expression, taken all reasonable care or have undertaken all the endeavors needed? Well, we would say it is different. We mean specifically here having to take all reasonable precautions and exercise all due diligence. The standard may be different than those in common law. Mr. Frankie Yik, I think we have raised similar questions before. So the driver may have the valid ride-hailing vehicle driving permit, but they are not driving their own vehicles. So this will probably only be identified in traffic accidents. So again, how can a passenger identify the connection between the driver and the vehicle? I guess we can discuss this in due course when we go into implementation of the provisions. Mr. Kevin Choi. Indeed, in the second phase, we will be fleshing out the arrangements that are beyond the scope of this regulatory framework, because this is just a framework, so that drivers and vehicles are subject to the oversight of passengers. I would say that the policy intent is very clear. Platforms generally have the relevant responsibility to, say, take precautions. We will say in our guidelines what responsibilities the platforms have. At least we will have the minimum standards, so these can be in the end some reference materials for the court's consideration should it get to that stage. These are related to the operational details, so I guess we can talk about these in detail in due course. Alright, please proceed. Thank you, Chair. We are on now Division 3 of Part 6A. There are 3 subdivisions under this division. 55G. The Commissioner may invite applications for ride-hailing service license. Section 55H. Application for ride-hailing service license. A company that wishes to obtain a ride-hailing service license may apply to the Commissioner. The application must be made in the form specified by the Commissioner. 55I. Decision on application for ride-hailing service license. The Commissioner may consider the factors set out in subsection 2, including the applicant's experience in operating such a platform, the applicant's financial capability, the applicant's proposed level of investment, etc. And in F, any other matters the Commissioner considers relevant. The Commissioner must give written notice of the Commissioner's decision, and if the Commissioner refuses the application, the notice must state the reasons for the refusal. 55J. Issue of ride-hailing service license. We have said in subsection 3 the conditions for the license may relate to one or more of the matters. The services provided through the license platform, the collection, transmission, storage, and provision of data, the keeping of records, etc. So these are the salient points. We will provide for the details in the guidelines. For example, in E, we talked about we have some requirements for directors and other persons. The specific requirements will be set out in the guidelines, and these will in the end become part of the license conditions. And in the legal advisor's letter, they asked whether there should be specifics on the license details, say the date. We will promulgate the details in the next stage. This is in line with, in general, the arrangements for, say, taxi fleet licenses, where we will have regulations spelling out the details. Thank you. Mr. Frankie Yik. So the Commissioner can ask for some information from such platforms, but we talked earlier about how the data may not be stored on servers in Hong Kong. If they provide inaccurate data, what penalties are there? Who's going to answer this question? Mr. Kirk Yip. Thank you, Mr. Yip, for your question. We require platforms to provide proper records, and this is one of the factors we'll consider when assessing the performance of the operator, and the commissioner may conduct an inquiry. Based on the inquiry findings, a financial penalty may be handed out to the platform, and there are 3 tiers: 50,000, 100,000, and 200,000. I have a follow-up question. If you suspect the data that the platforms have provided to be inaccurate, how can you verify that? If we have suspicions, I believe we'll try to obtain more information through different ways. For example, if we receive a complaint from a passenger to say there are some problems with the vehicles, and if the returns provided by the platform does not match the information provided by the passenger, we will need to verify the discrepancy. I don't know how they can obtain such information if the information or data are stored in another jurisdiction. I can't think of any way they can resolve this. I guess they can consider this after the meeting. We can ponder this after the meeting, but I think in general we would need to have data stored on local service, because we have drivers who are locals. We also have passengers who are locals. So the algorithm may be mainland or overseas, but there should be a certain level of processing in Hong Kong. However, we do take note of Mr. Frankie Yick's suggestions. But I would say this, with the framework we have here, it should be adequate for us addressing the concerns of Mr. Frankie Yick. Mr. Frankie Yick, I think Mr. Kevin Choi said it quite rightly. Would you request that platforms retain data on local journeys in Hong Kong? Mr. Kevin Choi, this is a direction we're considering, but then with storage, there can be different ways of storage. But this is more or less the direction we will take, because this is data derived locally. We do expect them to retain some sort of record in Hong Kong. Thank you. Please proceed. We're now on subdivision 2, sections 55K to section through 55M, obligations of ride-hailing service licensees. 55K, ride-hailing service licensee must ensure proper and efficient ride-hailing service to maintain to the satisfaction of the commissioner. And we do say specifically the public vehicle passenger transport service should be proper and efficient. The assistant legal advisor asked specifically about proper and efficient public vehicle passenger transport service, and our answer to the concern raised by the legal advisor is that the expression is used in different legislation relating to public transport. We also say specifically in subsection 2, in determining whether a ride-hailing service licensee complies with subsection 1, the commissioner may have regard to different factors, specifically whether the licensee ensures the quality of the service. Mr. Sunnyton, I have some questions. With the defining of service, it is about how a user can get from location A to location B, but sometimes there are also after sales services, especially when disputes arise. Say, when you have made use of such service overseas, when they have left something in the vehicle or when they're dissatisfied with the service, there is often no follow-up. So how can we make sure the quality of service is maintained to the satisfaction of the commissioner or citizens? Thank you for your question, Mr. Sunny Tan. We will flesh out the implementation details in due course and the specific licensing conditions. And in fact, when we talk to platforms attach great importance to customer feedback, and if we have a customer feedback mechanism, we can make it into a licensing condition. So let's say when a passenger leaves something in the vehicle, they can talk to the driver or the platform to get their lost item back as soon as possible. Thank you.
Next, 55L. So it provides that ride-hailing service licensee must keep and provide proper record of operational data. And in response to a request from the Commissioner, such data will have to be provided. Next, 55M. Commissioner may give direction to ride-hailing service licensee. And then for drivers and also vehicles under his management, the Commissioner will have to give such a direction in writing. And then for the detailed procedures involved, including the commencement date of that, those will be provided for under the subsidiary legislation. Next, subdivision 3. That's on page 21 of the marked up copy. First, 55N. Under this, the Commissioner may appoint public officer to conduct inquiry if he or she believes that there is there are irregularities, including the fact that the licensee fails to comply with the section in providing efficient service, or he has violated certain conditions, or he has failed to comply with the regulations applicable to him. And after the inquiry, the public officer will have to report to the Commissioner, and the inquiry procedures will be provided, including the time and location, and also the service of the notice, and so on. With regard to the letter from the legal advisor, it's asked, he or she asks about whether or not the relevant provisions will have to be included in 55N. We believe that that is not necessary. As to whether or not the licensee has complied with the request made by the Commissioner, or in determining whether or not the licensee has maintained efficient and effective service, then that would be incorporated. And if he fails that, then the Commissioner will think that he has not maintained an effective service under 55N, then a public officer can be appointed to conduct that inquiry. Legal advisor. Thank you, Chairman. Just now, reference was made about 55N. In the letter that I wrote, that is, in the letter that I wrote, in paragraph 4, I asked about the Commissioner. That is, in making that direction, that has to be in writing. So can the administration clarify? So will commencement date be designated in that letter? So will a particular provision be made in relation to that? Yes, can you respond? Yes, on 55N, for the detailed procedures in giving that direction, including designating the commencement date and also how the licensee should be notified and so on, well, those would be provided for in the subsidiary legislation. It will not be covered in the principal legislation. Okay, next. Moving on, that's 55O. It's about the financial penalties. The Commissioner, in considering the report made by the public officer, and if the offense has been committed, then financial penalties can be imposed on the first conviction, $50,000, second occasion, $100,000, and for the third and any subsequent occasion, $200,000. And if the licensee feels aggrieved, then under 55 set B, an application can be made, and then the transport tribunal can review the decision made by the commissioner, and the legal advisor are also asked that in imposing the financial penalty, what factors will be considered and whether or not the licensee can make representation. And under 55O, well, only after the public officer has completed the inquiry and after considering the report, and if it's satisfied that certain situations have arisen under 55N, then he will make that decision. And then in the provision, we will also set out the procedures to be taken, including the public officer has to consider the verbal or written representation made by the licensee. We believe that this mechanism should be sufficient to ensure that the licensee would have a reasonable chance to come up with different opinions or representations. Yes, next, 55P. If the two circumstances arise, the first is the commissioner, after considering a report made by the public officer upon completion of the inquiry, and if certain circumstances under 55N have arisen, and also if a financial penalty is imposed, and if the licensee has not paid in full in accordance with that section, then the commissioner may do one or more of the following. That is, cancel the ride-hailing service license concerned, suspend the license for a period of time, or vary the license. The commissioner will have to write to the licensee to notify him of the decision. Next is Division 4 under well, there are two subdivisions. It's about ride-hailing service or ride-hailing vehicle permits, 55Q. The commissioner may limit the number of ride-hailing vehicle permits via the Gazette. The commissioner may consider the actual situation as to in determining how many licenses should be issued, and this is a subsidiary legislation. Ms. Doreen Kong, thank you. I'd like to go back to 55P. I might be lagging behind. Okay, 55P says that the commissioner may cancel the license, but then 55P is about the licensees failing to take heed of the instruction or decision made by the commissioner, and then there would have to be a hearing, an investigation, so that a fine will be imposed, and if he fails to pay. So that's rather serious, because you have already violated the regulation, and then after you have been found guilty, you have been fined, and then if you fail to pay, then it's rather serious. How come under 55P you have been so lenient? How come you still permit him to vary the license conditions or have the license suspended for a period of time? If he's so defiant, if he fails to pay up the financial penalty, it's a platform. It's not just an ordinary driver. So why do you have to be so lenient? Why do you have to explain to him under subclause 3? So why do you have to be so lenient? Permanent Secretary. Well, under 55P, actually we have put in place a flexible arrangement. Two factors will be considered. Under 55O, we have already conducted the inquiry, and then a report has been submitted, and then the commissioner will come to a certain conclusion as to what should be done. And if he fails to pay the fine in accordance with our instruction, in fact, after the inquiry, we may not impose a fine at all. Or if we feel that there are circumstances whereby he can make some improvements through taking some measures, and after he has done that, he will still be able to continue to run the service. So there is some room to maneuver. That is, it's not as serious as to warranting an immediate suspension of the license, so it can be suspended, or the license conditions can be varied so that there would be more room to maneuver. So we have taken into account different scenarios so that there would be more flexibility here for the commissioner to deal with the situation as warranted. Well, I do have some reservation here, because 55P, why because under 55 you will have to comply with A and B, and if it's just A, then I can understand that is that they have failed to comply with certain conditions. Well, they might have been somewhat defiant, but then for B, you are sure that he has failed because he has failed to make the payment. That is very serious. He has failed to pay the fine. So you have already, he has already been convicted, and yet he has failed to make the payment. So why are you so lenient towards these licensees? Permanent Secretary. Chairman, thank you, Ms. Kong, for your question. Well, I've discussed with my colleague. In fact, our views are that there are different circumstances. So it should be or, it's not and. But then we can go back and think about it, because we want the scope to be broader so that in certain circumstances and then together with other circumstances, this set of penalties would apply. So Ms. Kong, what you said was right. But then we will think about how it should be drafted. So we'll get back to you later. Thank you. Okay, please move on. Next is 55R. The Commissioner made by notice published in the Gazette invite applications for ride-hailing vehicle permit, and this Gazette is not a piece of subsidiary legislation. Next is 55S. It provides that any private car register owner can apply for a ride-hailing vehicle permit, but then that will have to be done in a form specified by the Commissioner. 55T. The Commissioner may grant or refuse an application made under the relevant section, and if a decision is taken, then he will have to notify the applicant. And then he can also set a limit as to the number of permits to be issued, and if the number of applications exceeds that, then the Commissioner can also decide how to select the applicants. That would also be provided for in the relevant subsidiary legislation, and the Commissioner can only approve the application that has fulfilled all the conditions. The applicant has to have the ride-hailing permit, and he has also got to have the driver permit, and within 3 years he has held the ride-hailing vehicle permit, and that permit was not cancelled under the relevant provision by the Commissioner. That is to prevent somebody who has had his permit cancelled by the Commissioner to immediately file for another permit. And also, on the day of the application, the car would also have to have less than 12 years, will have to be younger than 12 years, and if there are other circumstances warranting a further amendment, then that could also be done by way of a notice in the Gazette, and that would also be a piece of subsidiary legislation. And also as to the conditions that he will have to meet, well, on the day of application, the private car would be less than 6 years old, and if it's in excess of 6 years, then they would also have to fulfill the requirement under Section 88A with regard to roadworthiness, and also in terms of insurance policy, they will also have to have third-party risk insurance, and also the hire car permit would also have to be enforced, and third-party insurance would also have to be in place. And also, the applicant would also have to give a written consent that the hire car permit is to be cancelled on the issue of the ride-hailing vehicle permit. That's to avoid the same car having 2 permits at the same time. Finally, the applicant would also have to pay the relevant fees for the permits concerned. Next is 55U. The Commissioner, in issuing the ride-hailing vehicle permit, he will have to make sure that the hire car permit is enforced, and also the applicant has already got the relevant driver permit, so as to ensure that any car will not be holding the hire car permit and also the ride-hailing vehicle permit at the same time, and also the same person would also not be holding a ride-hailing vehicle ride-hailing permit and also other permit. So under 4A to D, these are the conditions that he will have to look at, including the transport service to be provided, and also the maintenance of the vehicle, and also the policy of insurance would also have to be displayed, and so on and so forth. Ms. Doreen Kong. Well, if the commissioner decides to cancel the ride-hailing vehicle permit under 55U, would you notify the platform about this? Why do I ask this? Because the platform has the duty to ensure that the vehicle and the driver both have the permits. And if you cancel a car permit, and the platform might not be aware of that, how can it ensure that the car has the permit? Indeed, I can imagine that is the commissioner and the platform will have a computer system in place so that they can be connected, and then we would also enable the platform to verify whether or not the commissioner has already issued certain permits. So in designing that platform, we will also have to bear that in mind, so that if there is an initiative taken by the commissioner to cancel a permit, then the platform would also be able to update that, so that they would not be designating a car where the permit has been cancelled to provide the service. Next. Subdivision 2 is about cancellation, etc. of ride-hailing vehicle permits. 55V provides that the commissioner, if he's satisfied that conditions A to C have been committed, then he can decide to cancel or suspend or vary the permit, and he will also have to notify the licensee. Those include that the car has committed the provisions under Chapter 374. That is, they have been carrying goods and so on, and also under the provision in relation to the linking up between the driver and the cars and so on, and also the licensee has failed to comply with Cap 374's provisions applicable to him.
Next. Division 5. Drivers of ride-hailing vehicles. Subdivision 1. Ride-hailing vehicle driving permits. 55W to 55Y. 55W. Application for ride-hailing vehicle driving permit. A person who wants to apply for such permit must be made in the form specified by the commissioner. 55X decision on application for ride-hailing vehicle driving permit. The commissioner may grant or refuse an application. The commissioner will issue a notice once they have made a decision, and the commissioner must not grant the application unless the applicant is age 21 or above. The applicant is the holder of a valid full driving license to drive a private car or light goods vehicle and has held the license for at least 1 year before the date of application. The applicant has within 3 years before the date of application passed a driving test. The applicant has not within 5 years before the date of application has been convicted of an offense under the relevant sections. The applicant is the holder of a permanent identity card or is the holder of an identity card other than a permanent identity card is not subject to any condition of stay other than a limit of stay. This is on par with the requirements for taxi and public light bus drivers. If the applicant was disqualified from driving, the period of disqualification has expired on or before the date of the application. We also require some physical fitness requirements specified in the ride-hailing regulation to be met. If the application has held a ride-hailing vehicle driving permit within 3 years before date of application, the permit was not cancelled during that period. This is again to prevent a new application being submitted by the applicant if they have their permit cancelled. And there are fees attached with such applications. Thank you, Ms. Doreen Kong. I want to ask about 2E in particular. For the sections you mentioned, you did not include section 37 in relation to dangerous driving. Why did you not include a reference to the section? Other sections involve offenses that are quite serious. I've checked that. But section 37 is also quite serious. Why didn't you include that? on subsection 3. If one holds a valid full driving license to drive a taxi, subsection 2C and D does not apply. So basically, one will not be required to take the test or complete a pre-service course, correct? Mr. Kirk, thank you. In E in particular, we have referred to various sections that involve serious offenses. We did not include the reference to section 37 because we have considered the requirements applicable to commercial vehicles, which is why we did not include section 37, because section 37 is not applied to other commercial vehicle types. But we keep in view of this situation. If anything needs to be updated, we will consider that. As for what the member said about subsection 3, it is indeed the case that they will know if they hold a valid full driving license to drive a taxi, one is not required to take the test or pre-service course. It is because if they are already driving a vehicle for hire or reward carrying passengers, we believe they already have the necessary skills and experience. We will not need them to take a test or do the course. Alright, for the benefit of members, let's take a 5-minute break. Thank you.